Welcome to our third annual MLK Convocation, hosted and organized by the Law School's Diversity Committee. I'm guessing that most of you are members of our community, but just in case we have some outsiders, I'm Gary Jenkins, the Dean of the Law School. And this event provides an exciting and an important opportunity for the law school to come together and to honor Dr. King's legacy and to reflect on the continued relevance of his work, his effort, his message, his thought on law, on our community, on the work of our students, and ultimately the work that they'll undertake throughout their careers. I think that often when we think of Dr. King, when we think of the civil rights movement, and certainly if we think of those two in connection with place, we think about the South, right? Perhaps Montgomery and the bus boycott comes to mind, or Little Rock and those 9 school children, or Greensboro and the Woolworth's lunch counter, or Birmingham and its city jail, or Selma and the Pettus Bridge are some of the things that may come to mind. But what about the North? Did Dr. King's message, his philosophy, his thought speak to the North? And as we prepare to host the Super Bowl right here in our home city in less than 2 weeks now, there's a lot of talk about our region as it's being promoted as the bold North. And so for our theme today, we chose Facing North, Implicit Bias in Minnesota Courts. So we're going to look at ourselves, we're going to look at our region, our justice system. We're going to talk about new developments in research and understanding of race and racial constructs, and help us think about the future, help us think about where things have been and where things are going. If we look at some of King's written statements, his quotations, while he didn't use the term implicit bias, he highlighted, especially in the latter parts of his career and in his writings, systems of society, systems of thinking that reproduced prejudices. Okay? So let me give you some examples. In a 1964 interview with a publication that was once reputable before it turned to spurious rankings of law schools, he said that many people in the North have come to realize that they have probably had much more deep-seated prejudices than they had been conscious of. I think that this whole issue is out in the open now in a way that it has never been before. It's something like a boil, which if you kept covered up, will never be cured. Only when you open it up to air and light that it can be cured, even though it's ugly for the moment. And then in 1965, Dr. King commented on the topic of Northern self-image versus reality in another interview. He noted that the Northern white, I quote, having had little actual contact with the Negro, is devoted to an abstract principle of cordial interracial relations. The North has long considered in a theoretical way that it supported brotherhood and equality of man. But the truth is that deep prejudices and discriminations exist in hidden and subtle and covert disguises. So if we carry some of those themes forward, if we consider some of the extensive research that's been documented that proves some of the disturbing effects of implicit racial biases in a variety of settings, that helps to explain some of the substantial inequalities that continue to persist between white and minority Minnesotans in education, in employment, in housing, in healthcare, in policing, and in the criminal justice system, as just some examples. So our conversation today challenges us to collectively face north, including acknowledging how deep-seated biases may impact outcomes and our daily interactions in our field. And certainly, this topic could probably fill an entire course that would take a semester to cover. We're just going to scratch the surface, but we're going to do so in ways that I think are going to be really important and enlightening because we have two fantastic guests with us. So join me in welcoming our panelists today, Judge Pam Alexander, class of '77, and Professor Francis Shan. So Judge Alexander, who serves on Minnesota's 4th District Court, she is a Minneapolis native. After graduating from our law school, she began her career in public interest law with the Legal Rights Center, where she represented low-income defendants in criminal cases. She eventually then moved on to the prosecutor's office, joining the Hennepin County Attorney's Office in 1980. In 1983, she became the first black woman judge and the youngest judge appointed to the Hennepin County Municipal Court, which later merged into the 4th District. For 25 years, she presided over civil, criminal, and juvenile matters. Among her many significant cases was a 1990 case, State v. Russell, holding that differential sentences for crack and powder cocaine possession resulted in racially unconstitutional sentencing disparities. That was a pioneering ruling at the time, which was ultimately upheld by the Minnesota Supreme Court, and her ruling was a really important puzzle piece in setting the stage for the more recent successful efforts to change sentencing guidelines to reduce mass incarceration inequities. In 2008, she left the bench to become president of the Council on Crime and Justice, which supported research and advocacy to promote a more just and equitable criminal justice system. And then in 2013, Governor Dayton reappointed Judge Alexander back to the 4th District Court, where she now serves. In her distinguished career, she has earned dozens of awards for her advocacy work on behalf of numerous legal and community initiatives. Now, also joining us is a face familiar to many of you, Professor Francis Shan. He teaches criminal law, evidence, and law and neuroscience. He is one of the nation's leading pioneers in the field of law and neuroscience. He's a graduate of the University of Chicago and Harvard Law School, and also has a PhD in government and social policy from Harvard as well. He worked with the University of California at Santa Barbara and taught at Vanderbilt Law School before joining us in 2012. Here at the U, he conducts empirical and interdisciplinary research at the intersection of law and the brain sciences. He's the co-author of the first law school casebook on law and neuroscience that explores the implications of cognitive neuroscience on criminal law, tort law, legislation in the United States, as well as a variety of other issues. And to make the rest of us look bad, in his spare time, he runs. But he doesn't run like you and me. He is a 3-time national champion in his age group as a master hurdler. So that's some hobby. So what we're going to do is we're going to start actually with Professor Shan. He's going to lay, I think, some of the groundwork, help us understand implicit bias and how it works. And then we're going to turn to Judge Alexander to talk about how implicit bias manifests itself in and around the courtroom and its implications for judges and lawyers. And then we're going to have discussion. So, Professor Shan.
Great, thank you. And I might just do this so I can see everyone. Thank you to the Diversity Committee and Judge Alexander, Dean Jenkins, and to all of you for making this a great event. I've been charged with sort of giving a 10-minute high-level overview of implicit bias, and I'll do my best to do that, with the caveat that there are at least some colleagues of mine who will not even spend only an hour on implicit association tests because they feel if you don't have the full day, there's almost a danger that a little bit is not enough. And so I'm going to try and be pretty careful in what I say, but I will at the end also make reference in honor of the day to a sermon by Dr. King called The Transformed Nonconformist. So tuck that away, we'll get to that. Here are three things that we need to start with before we talk about implicit bias. Your brain is a decision-making machine. It is making tens or hundreds of thousands of decisions every day. 20,000 times today, it's decided whether or not to put a little bit more oxygen in your body. You're going to breathe about 600 million times over the course of your lifetime, and you're not going to think about hardly any of those. Maybe you came from upstairs. You had to figure out how much pressure to put on each foot and where to do it. It's really tough to tell a robot to do that. You did it without even thinking about it. So we make decisions all the time. That's the first thing. The second thing is because we make so many decisions, we need lots and lots of shortcuts. We would be paralyzed. Indeed, sometimes we feel paralyzed with too many decisions. Some of those decisions you don't have to program. You're just born. You didn't have to learn how to breathe. But others, many, many others, are culturally programmed and facilitated. So I see that every single one of you came in, and I didn't notice a single one of you come up to this thing, say, what is this? It looks, do I get under here? Do I stand on it? You don't know what to do, but you did. You didn't think about it. When you see that object, you immediately think, what I do with it is I sit down. Now, you weren't born thinking about that, which is why those of us who have little kids spend much of our time trying, no, don't do that, don't do that, right? What not to eat. So that's the second thing. We need lots and lots and lots of shortcuts. And that leads to the third thing, which you put those two together, that lots of the shortcuts we use for decision making are good. We need them, but not all of them. Some of those decision shortcuts that we use, and we can use the word bias, the wording is kind of challenging, but if we use the word bias to talk about an unconscious decision, some of them have difficult, disastrous outcomes. So transition to the topic for the day, which is implicit racial bias in the criminal justice system. Scholars and practitioners in the area, when we use that phrase, we're not talking about that universe of really good biases, like you didn't have to spend 3 minutes figuring out what you do with that object. You just knew to sit down. We're talking about unconscious decisions that have negative justice outcomes. What are those sorts of outcomes we care about? Longer criminal sentences for certain defendants of certain races or ethnicities, higher bails, unfair treatment, a host of other unfair targeting practices by police, unfair charging decisions by prosecutors. From start to finish, disproportionate and maybe ineffective use of parole and probation, you name it. Along the way, there are many decisions being made. Some of those decisions are likely affected by these shortcuts that rely upon race of the defendant. That's the challenge. So let me tell you a little bit about where the research is. It's not new, but it's also not really old. That is, it's maybe a few decades of research in psychology, the social sciences, now increasingly neuroscience. And what we found is that all of us, these US populations, and there's some cross-national variation, but all of us we have some of these decision-making shortcuts, which in the lab would seem to suggest that we have some negative attitudes towards certain races. Now, that's not easy to hear. Indeed, there's research that shows that we don't like to hear that. And one of the reactions that we usually hear when we hear it is, not me, because I'm egalitarian, I'm from Minnesota, I could never think that way. And yet the research, and this research is done in labs, then try and correlate it with real-world activity. The research suggests that all of us, even those who exhibit and demonstrate and express egalitarian views, hold some of these decision-making shortcuts, these biases that affect the way we think. One of the challenges over the last decade that research has done is to say, well, okay, researchers, you've got these tests in the lab. One of the most notable ones is called the Implicit Association test, which relies upon looking at reaction times to an association between faces or other, typically faces of certain races, and then negative or positive valence stimuli. And one of the challenges has been, okay, you may show that there are biases with your test in the lab, but what about in the real world? Because that's an artificial laboratory setting. Now, we still need more research, but the evidence is mounting that in applied legal context, and it's just not law, it's in society as well, but in legal context, legal actors, we've tested lawyers, we've tested judges, we've tested potential jurors, that these biases are showing up and likely account for some, maybe a great proportion at different stages of the inequities that we see. Right? And I think many of you are aware of a variety of inequities by race, again, from sentencing, charging, probation, parole, along the way. So that's what we know. So what do we know so far? We know that we have these biases, even if we think we don't. We know that in some instances, we don't know exactly how many, but certainly in some, they likely have an effect on these justice outcomes. So you say, okay, well, what do we do? And that's where a lot of the research is headed right now, thinking about what can we do if we're aware of these biases to counteract them. And there are sort of several different ways to think about these. And I'll kind of give you a sense of where the thinking is. So one is there are a set of individual level things that we can do. There's a great piece, if you're interested in reading more, published last year by the ABA. It's a volume called Enhancing Justice. And one of the chapters in there is by a Cornell law professor, Jeff Raklinski, and a California judge, his co-author. Jeff has been studying judges for years and years and has shown that they exhibit virtually all the same biases that we do, all the decision-making biases. But he's also found that there are a number of ways that we can sort of break up those shortcuts. These include things such as being more mindful of the decisions we're making. They include things such as trying to disassociate and do what's called perspective taking in the literature, meaning things instead of just automatically thinking and doing, pausing and reflecting and trying to take on a new perspective. They include simple things such as instead of offering an oral decision on the spot, taking it back to chambers and writing a written opinion. A variety of individual level ways that things can matter. I do this in my own work. I'm really insistent on anonymous grading, even when it's not required. I teach an undergraduate class, 110 students, variety of all sorts of students, and unlike law school, anonymous grading is not required. I require it of myself and the TFs that work with me because I don't trust that any host of biases might affect our grading. So there are individual level things that we can do. But there are also systemic things that we can think about. And this is one of the, I think, the most interesting trends in the research. And the idea is that we might not want to think of implicit bias as an individual trait, something that I have to fix and detrain myself or debias myself, though maybe it's that. We might want to think about it as a state, a certain state that I fall into under certain context. And to the extent that we think about it as that group context, we begin to look at new avenues for addressing the issue. Some of the research that we've done recently in my lab, I think, supports this idea. We ran a study, and we asked potential jurors, these were subjects, to assess the mental state, the mens rea of a criminal defendant. What they didn't know we were doing is that we were manipulating the name of the criminal defendant. Some of our subjects read about a defendant named John, others read about Jamal, others read about Lakeisha, and others read about Emily. Now, we picked those names because in the economics literature it's been shown, and in other literatures, that if you just send out resumes and you randomly assign those names, guess what? Lakeisha and Jamal get fewer interview callbacks than Emily and John, even if everything else remains the same. So our hypothesis was, well, we're going to find the same thing. What we were asking subjects to do was determine whether the defendant was acting purposefully or knowingly or recklessly or negligently. If you remember criminal law mental states, right? Those mental states matter. And if you remember criminal law mental states, it's really tough to figure out, especially like that knowing, reckless line. How can you ever figure it out? So here's the bottom line, what we found. Lakeisha and Jamal and Emily and John were all treated the same in our study. And that was a real puzzle. In fact, I kind of sat with this data and spoke with colleagues for about a year and a half, presented it to our colleagues here. And ultimately, how I think we can explain those results is what psychologists call a distraction task. They were not focused on the race of the name. They were so busy trying to do this really hard thing, like what mental state did they have, that they weren't thinking about the race of the individual. And there are other contexts where this matters a lot, that it's not the thing we encode. We don't have to automatically encode race. In brain scanners, they've done studies where sometimes they ask the subject to focus on the race or the gender. Other times they ask the subject to think about, would this person prefer a banana or an orange in the morning? Well, it turns out that if you're thinking about, is that a banana or an orange person, you're just a lot less likely to encode some of the things you are when you automatically encode race. So there are ways that we could think about context and whether or not we're sort of upping or tampering down our instincts, this state. And then finally, I think something that needs to happen desperately is we need more transparency about the outcomes. This is not just the researcher talking. This is sort of the practical decision maker talking. You know, imagine professionally, probably a number of you follow professional sports, or at least enough to know that the major trend the last decade in evaluation has been the adoption and introduction of advanced statistical methods and metrics. We don't just rely on the old school. Remember the old school, we say, I'm just going to take a look and that player's going to be something. I just know it. I just know in my gut. I hear this from judges a lot. They say, look, I can tell. When someone walks into my courtroom, believe me, I've been doing this 20 years. I know. And anytime I hear that, I get concerned, right? So how do we address that? With data. We've got to have some better sense of, from the beginning to the end, what the disparities are. By the way, that data has only come in part from activism the last couple of decades. How those outcomes are related to the decision-making process, which is often opaque, especially in a district attorney's office. And that then gives us some purchase on where and how we can intervene. So there are things we can do. There are more, and we could talk about them. But I want to finish with just a thought, given the context. This is from this sermon, Transformed Nonconformist. So wonderful sermon, not one of the regularly quoted from Dr. King. But he started with this, is from the mid-1950s, with this quote from Romans. Those of you who are familiar with it, here it is. And not be conformed to this world, but be ye transformed by the renewing of your mind. Be ye transformed by the renewing of your mind. Addressing implicit racial bias is renewing of the way that we make decisions, refreshing, resetting, trying to do something different than we've been doing for a long time. And it's very difficult. You know, the opportunity here is that unlike some things, such as age, the best thought is that we really do encode that automatically. It's really going to be impossible for you to see a baby and just think, let me imagine this as a 70-year-old. It's just, we encode age. We don't actually likely encode race, and there are reasons for that, which means that it's potentially malleable. But if we've been in an environment and a culture where we begin to associate one thing with another, it becomes can be as difficult as for you to get to a chair and do something other than sit down in it than it is to maybe see race differently. So to combat implicit bias is to be a nonconformist. And it is not easy, and that's Dr. King's point. He said this about nonconformity: there can be no doubt that the command of our text, do not conform, is difficult advice for any modern person. And it's difficult because the second that you nonconform, so if I do this, I'm not going to sit in the chair, I'm going to stand in the chair. All eyes are on you. And it's scary, because many of you think, why is he doing it? Just sit down. Everybody sits down. You always sit down. Dean didn't tell you always sit down. It is not easy. And that's what going along with systematic racial injustice is about, is sitting there saying, I'm just going to go along. And it's difficult, because if you're the line prosecutor in a county attorney's office where the county attorney doesn't care much about implicit racial bias, what do you think is going to happen? You start raising your hand every time and say, well, I think we need to deal with this. You're not going to be a line prosecutor for very long. If you're a district judge, trial judge, and every time you're sending up opinions, you raise this, you refuse to do certain things, you're going to get turned over every time. Probably not going to enjoy the situation, right? So it's difficult. But here I think is some hope. These Dr. King's words. I'll finish with this about the value of standing up and being a nonconformist, the value of challenging our own biases and those of the system. My friend, said Dr. King, it is the nonconformists that have made history. It was the minority that fought for religious liberty. It was the minority that brought the freedom of scientific research. In any cause that concerns the progress of mankind, put your faith in the nonconformist. Put your faith in the nonconformist. Tackling implicit racial bias is not easy. It requires non-conforming. My hope is that we'll do it.
Thank you. Judge Alexander.
I feel like I should just say ditto and just go to questions, but I'm gonna talk to you a little bit about how we have been trying to deal with implicit bias in the courts and what we have done to try to kind of combat that. But I want to go back a little bit to talk about the role that the law has played, quite frankly, in implicit bias itself. Because of the fact that we in this country actually legally discriminated against people of color for many years, and it has been actually very recent that those things have been undone, you have been acculturated to see certain groups certain ways. A lot of times most folks don't want to talk about that. Mainly, also because, you all were probably born, a few years ago. Because you're thinking, okay, I was like a full adult in 1968. So I kind of lived through a bunch of this stuff and saw the laws change. And I was part of Separate but Equal, and I was part of going through the South and having to get off the sidewalk when white people walk by. So that was my experience. That's not yours. It's not my kids. It's not any of your real experience that you've seen, except for a couple of people who have gray hair in the back. So all I can say is that a lot of this is a very recent phenomenon. And it is work that I think we've made some strides, but there's a lot more strides that need to be made. One of the things, one of the things I love about lawyers, and I teach law school as well, and in each of my classes, I do make the law students go back and do the implicit bias tests that the professor talked about. And it's hilarious, the difference in kind of the responses that I can even see generationally that we're getting. So when we made all of our judges take the test, they wanted to argue about, oh, this isn't valid, this isn't this isn't blah, 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 blah. Like, the students are like, wow, this is great. I can kind of, okay, I'm getting it. And it had a much more open mind generally. Now, I did have a small cohort that said, is this really valid? I don't really, this is uncomfortable. I'm like, well, part of being a law student is being a little bit uncomfortable, but it's also learning, and you're open to learn, whereas a lot of old lawyers aren't. A lot of old judges really aren't either. So we've had to do quite a bit of advanced legal education, and there's some reason why you all have to go to take continuing legal education the entire time you have a license to practice, is because the law changes all the time and you have new things that you have to look at. And implicit bias we've been looking at in our courts for quite some time. And really trying to talk to judges about their responsibility to be sure, because we're the ones that are charged with making sure that everything happens is just, that we have to be sure that bias doesn't creep in, not only with ourselves individually, but with jurors and with lawyers. And so we have to be vocal about that. That hasn't been something that has been universally embraced. However, it is definitely being talked about and pushed by a number of us. Some years ago, we decided, actually in 2015, we came out with this implicit bias bench card for judges to look at how they make decisions and to kind of slow those decisions down, very similar to what the professor said, because of the fact that when people make rash, fast decisions, they tend to do it with all their biases intact. And we want them to slow that decision-making process down. So we gave one of these to every single judge in the state. A couple people I sent two to. Because I said, they're gonna misplace that first one on purpose, but I want them to get it. because actually, you know, I sit with some of these folk, and I'm going to give you an example. I went up to teach a implicit bias seminar up in Duluth, and we were talking to just a number of judges. And you know, judges, they get real funny, so they don't want to be in groups with like anybody other than other judges. So I said, okay, so we won't bring anybody in but other judges to talk to you all about this. So we sat down and we said, well, give us some examples of circumstances that you've seen. And one judge said, well, you know, right after we got our casino and some of the tribes are making a lot of money, we just saw a very different attitude with our Native Americans. They got real bold. And I said, well, what do you mean? So I was like, what do you mean by that? And they said, well, you know, we used to say, you know, you have to do this, you have to do that. And they're like, hey, look, hey, what's the bail money? I'm out of here. And they were mad about it, that they weren't what they considered to be humble or got emboldened by the fact that they now had funds to be able to work their way through the system. Or I had another judge say to me, well, you know, I really have problems with African American males because they have no respect for women. And I said, okay. I said, all African American men? And he goes, well, the ones I've seen. So I said, well, Judge, where do you work? And he said, well, I work in domestic violence court. And I said, okay, but are you going to extrapolate that to every African American male ever? And he goes, well, that's what I see, and they're all like that. And I said, well, kind of, sort of not. I said, you know, I have a husband, I have a father, I have a couple brothers, never been in DV court in their life. So I just want to know how you're kind of extrapolating that to absolutely everyone. And he said, well, you know, really that's what they're like. And it took me probably 20 minutes to convince him, because then I finally said, well, do you have any black friends? Do you golf with anybody black? Do you go on fishing? I mean, what do you do? And he actually said, no, I have no friends of color at all. And I said, well, you know, I'm going to find a friend for you. Because I can't, because I told him I don't want you to, that is just kind of an unrealistic way of looking at the world. Now, I see what you see in your court every day, but that isn't something that you can extrapolate onto the world. So those are the kinds of implicit bias that we're seeing that people are actually getting from whatever personal experience they have. And it's kind of typically Minnesotan. Minnesota is one of the whitest states in America. So in case y'all didn't know that, I'm gonna let you know. It actually is. And Minnesota has had a lot in its history, a history of racial violence. We had lynchings in Duluth. We've had all kinds of racial issues here that are not talked about widely. So when the police shootings happened here, that was not surprising to some of us, because there have been issues in this state for quite some time. We are behind a little bit because of the fact that our populations of color are so small that we haven't had to deal with these issues a lot. So we're behind other states that are, that people look at and compare us to only because we haven't had to deal with those issues. Now we do, okay? And it's okay. You know what? Because I have a lot of faith in Minnesotans. I think they're great. They kind of do get up to the challenge, and will look at trying to make change. I think it is a process that we need to really recognize and know that we have to change and be open to that change. And the people who do that are lawyers. Y'all are the drivers. I tell this to my students all the time. The law will drive a lot of this, and you're going to be the ones that are going to have to push that forward. Those of you who are trial lawyers, you're going to have to say, okay, when I'm in a trial, I have to ask the jurors the race questions. if you have a client that's a client of color. You can't shy away from that because, in fact, that might make you uncomfortable. One lawyer told me, and I said, well, your client is African American. This was in a civil case. And I said, you're not going to ask any questions about race to any of these jurors? And he said, why would I have to do that, Judge? And I said, because race does matter. And we also did a study showing that jury verdicts for African American plaintiffs have tended to be a lot smaller in similarly situated circumstances. So you need to ask those questions. And he said, well, I'm just very uncomfortable, Judge. Can you do it? I said, fine, I'll do it. Whatever. However, but we're going to ask those questions. So I asked the questions for him.
What kind of questions did you ask?
I asked, more so generic questions. We asked, do you have any encounters with African Americans? Do you work with African Americans? Do your children have friends that are African American? Have you ever had an African American person in your home? Many, many people, and I'd say much more than you would imagine, say no. And so they'll say, well, yeah, we have friends, but no, they don't come over. So you're like, oh, so they've never been in your house? They're like, no. And so those are the kinds of questions we ask to find out what that real interaction is and if there is any real implicit bias in it. We also tell jurors that they should, if they feel like they have any biases toward any community of color, they have to set those biases aside. And then we kind of tell them what they should do. So it is something that we're working on. We have our bench card, we just redid our jury video. We've put in our jury instructions, questions on implicit bias. We've also put in our regular questioning of the jurors, questions on race now, which we do routinely. Well, let me go back. Which we should be doing routinely. So the judges have those tools available to them because we printed them all and disseminated them statewide. But of course we can't make them do them. But they have the tools and they're there. So I think it's also incumbent upon the lawyers to say, well, Judge, if you have these questions, can you ask them for us? Or if you don't want to ask them yourself, or to ask them yourself when you're in the courtroom, because it is definitely appropriate for you to do so. But I want to leave you some time for questions, so I'm going to quit talking and turn it over back to the dean.
Great, thank you both. There's so much there for us to talk about. Let me start by, there are responses to, once you understand implicit bias and you say, we want to take it seriously, you can think about it on an individual basis, but also on an institutional basis. And you've talked about both approaches. How is there a right way to divide the time, to divide the energy? Are we best thinking about the kind of institutional approaches? I would consider the bench card a kind of institutional response to the problem versus an individual trying to deal with individuals' hearts, minds, behaviors, practices, and how should we be thinking about that? Is it a both and, or is there one that's more likely to yield results? What do you think?
I think it's really a both and it's something that has to consistently be done, especially amongst the judges, because the turnover in judges is actually a lot higher than you think. So we have new judges on a constant basis, and we have to let them know that this is a priority and this is what needs to be looked at. And then we can get to them actually easier on an individual basis, once they know that it is something that systemically that we're looking at and that we want them to be very aware.
Yeah, I think the two are mutually reinforcing. I'm wondering if you might share, because I want to mention what the story you were telling me before about the prosecutor that in his pictures on the wall.
Yeah.
Would you mind sharing that story? Because I want to add on to it.
As mentioned before, I was a prosecutor prior to becoming a judge, and I went into the prosecutor's office and was meeting all of my colleagues and my new colleagues. And I had one that had pictures of a bunch, maybe about 20 different African-American guys on his wall, 8x10 pictures. And some of them had X's drawn on them, and then some of them were there. And he was saying, well, these are just the people, that my top 20 that I want to prosecute and get off the street. So I kind of looked at it. I said, you ain't no white people you want to get off the street? Just these 20 brothers right here? And so he said, yeah, this is my list. And, he says, yeah, as soon as I convict them, I put a big X on them, and I know they're off the street. And then he kind of left it up there. I said, well, I find that a little offensive. And I said, not even a little, kind of a lot offensive. And so he said, oh, no, you could be offended by this. These are bad guys. And I said, but there's a lot of bad guys in the world, but you only pick these 20 ones that happen to be black. And I said, and that it makes me a teeny bit uncomfortable in the fact that I'm the only African-American lawyer in here, and then I'm walking in and this is what you have up as your mantra. And I said, I'd appreciate it if you take it down. And he kind of went ballistic. He wanted me to tell you that.
Well, here's the reason why. So this goes to the individual, to the institutional. You imagine that, I was just struck when you mentioned that, because some of the research suggests that at least one of the things you might do is imagine a screensaver, and the screensaver would replay, talking about African American men, images of wildly successful African American men, just again and again and again. And the contrast couldn't be more striking. Mm-hmm. So every day this colleague of yours was, however many times, without even knowing it, associating that image with something bad. Again and again and again and again and again, just every spare moment. So individually, here's the answer to the question, at least my view. You could imagine that someone of those line prosecutors hears this talk and says, all right, I'm going to go tomorrow, go to Hennepin County, my desk right there, I'm going to change my screensaver. It'll probably take half a day, quarter of a day, an hour for someone to walk by and say, what's going on with your screensaver? And then the next one, what's going on with your screensaver? Right? That's really tough, I think, for an individual to do. On the other hand, if suddenly it came down from on high, here's the screensaver you will use, there's going to be a lot of resistance. So I think it's got to be both, but there has to be some institutional buy-in, because I think it's too tough for individuals. Now, I don't think most individuals have your gumption to just get up and say. I could see a lot just kind of walking past, feeling the same way, but maybe not standing up. So I just am striking. It's just the exact wrong thing you want to do if you want to tackle your implicit biases, but it's hard to work individually without institutional support.
Right.
Well, we also did a study when I was at the Council on Crime and Justice on imaging of people of color through the Star and Tribune. And so we followed the Star and Tribune for a year and saved images of people of color, and 98% were negative. And so we took it to their editorial board and we said, 98% of the people of color that you showed was all negative reporting. And so we would like you to show communities of color doing like normal things like you show white people doing, like roller skating and going over to the dome or sitting at a game or whatever, all these things that we normally do, but you don't show it. And the editorial board said, no, we don't do that. I said, oh, no, but we followed you. And here's every single image that you showed, and this is what it looked like. And these were the two that you showed people doing something positive. Everything else was negative. And they actually did change their reporting based on that. So now you see happy people of color occasionally in the paper.
In light of the time, I have a list of questions that I could run through, but I want to make sure that we bring other people into the discussion. So, Professor Mayo.
So I think so much of implicit bias happens at the attorney-client kind of level, because that attorney, when they meet with a client, is assessing them, assessing their credibility, assessing their the cause of action, the potential relief that they might have. And I would love your opinion on the concept of mitigating implicit bias as part of an ethical duty, as kind of something that you learn in your ethics courses, and that way permeates to all lawyers and to prosecutors and to judges that way.
That's probably a good idea to try to put that in. We try to do that in making sure that, to maintain your license, that you have to do a certain amount of with diversity training. Actually, when we put that in, we wanted people to do kind of implicit bias type things in order to maintain their license. And so you have to have 1 or 2 credits for that to maintain your license. But that's kind of, we put that in probably 10 years ago, and it's gotten a little bastardized by it, unfortunately. So it's not really going at what we were trying to get at. We were trying to get at that people would do like implicit bias training, would kind of figure out how to do better when they're talking to people who look differently than them, whether they're clients, witnesses, because oftentimes witnesses and victims are going to be different races as well. And so how do you relate better to folks who are different than you? And that's what that was for. From that, unfortunately, but it's still there. You can use it to that end, but people aren't doing that as well. So, and they keep trying to overturn it every year. So it's been a constant fight.
Yeah. Student.
I had a question on being the nonconformist and attempting to kind of point those, attempting to point out issues of bias or implicit bias. How do you recommend that be done so that you don't get, not a prosecutor for long or whatever position you're in? How do you empower yourself to do that?
Well, it's a great question. I think one of the answers is banding together. So this wasn't a solo project, the bench card, for instance, but a committee of concerned, organized individuals. I would also suggest, the old tradition of organizing. So the county attorney is a good example. There is almost unfettered discretion in county attorneys' offices. And if a county attorney were organized and elected to address some of these issues, that office would change because now you have a very different approach from on high. So I think those at the system level are probably the keys, because I do think that realistically it's very tough to be a single person swimming upstream. And I want to echo what Judge Alexander said about just the history here. How is it? It's a great mystery. How can we have been 30, 40 years of so-called egalitarian thinking, right? As you said, you're not in a generation where for most of you explicitly you've heard this. And yet if you take a bunch of these association tests, and I would too, we'd still score certain ways. And I think it's because of the history, the late in the media. There's a lot of stuff out there. So I think it's tough, if given that, to resist it without a significant amount of organization.
Deb?
Judge Alexander, it was interesting to hear about things that are being done to help jurors understand implicit bias. And I'm curious whether you think where the best intervention point is. Is it in voir dire, where you're talking to potential jurors? Is it in instructions, where you're helping them? Is it both? I know there was some resistance initially to having implicit bias in jury instructions in California and then coming here. And so I'm curious where those inflection points are. Obviously, sentencing and judges are important on implicit bias, but if it's getting involved in the conviction in the first instance, if there's implicit bias there, the sentencing stuff will pile on. But if we could be addressing it at the conviction level, I think would be an important first step.
Yeah, what we try to do is even in our jury summons, we start asking those questions. So when we summon people in, we say, okay, you're going to come in, you're going to be the finder of fact, but these are the things we want you to be aware of before you get here. Then we're redoing our jury video now, where we are going to talk explicitly about implicit bias. And there's some of my colleagues think we should talk about explicit bias too, since we're seeing a bit more of that these days. But so we're going to put that right in our jury video. Now this is all before they get to the courtroom. Then we will have judges ask the questions, and then hopefully lawyers will ask follow-up questions to those. So we're hopeful that if that is done routinely, that we will get at some of this. So we're starting it even before they get there.
Judge, I'm going to take the privilege that Professor Shan did and ask you to talk a little more about explicit bias that we're seeing, and we talked about that earlier before, to the extent that you can talk about what's happening and what you're seeing.
Yeah, we're seeing some really interesting reactions from jurors during questioning. You know, jurors are told, you know, you have to answer these questions, and people are coming in telling us specifically, you know, if the defendant is African American or Somalian or Native American, I don't like those groups of people, I will not be fair. Like, oh, you're not even going to try to sugarcoat it a little bit? They're not even, no, you know, all of those people are terrible. And we are getting some of those responses, or we're getting responses that are, that show people's biases very, very readily. I had one lady who said, look, I don't like coming downtown at all because I don't like being around you people. And I said, okay, so what would you people be? You know, and she goes, well, not you, Judge, because you're probably nice. But I don't like, and then she listed every community of color out there, saying, I don't come in contact with those people, I don't want to, it makes me nervous, I don't want to be on this jury. And so I questioned her a little bit further. It was obvious that, you know, she didn't want to be on the jury, so I obviously let her go. Or I had one guy who came in and said, you know, it was a drug case. I had asked him, this is what I was telling Dean about earlier, it was a drug case. And so we asked anybody who had experiences with anyone in their family that had either had an experience with drugs. And this guy raised his hand and he said, yeah, his son had overdosed his first year of college. And so, you know, I said, well, you know, I'm very sorry for your loss. Can you tell us a little bit more about that? Trying to figure out whether he could be fair on a drug case. And he said, well, it really is the fault of President Obama. So I said, really? Oh, okay. You know, how did you, oh, I said, well, how would President Obama have anything to do with that? And he went on to explain to me that, you know, he was the worst president ever, and that if he kept drugs out of the country, his son would have never overdosed. And I said, well, do you think that there's any kind of personal responsibility in that? And so we had some more of a discussion, and then just found out that he was very, you know, obviously had a ton of biases. And so we said, okay, I don't think he might not be a good person for this particular jury. So we are getting some of those kinds of responses, and we're getting people who are coming in on juries saying, you know, I'm a Trump supporter, I believe everything he says, and I don't really believe that you should be the judge here. Like, alrighty then. Nice of you to come. We'll see you later. So we are getting more and more of those types of responses.
Well, unfortunately, we have to, we're running out of time, and that's a sobering reality of the range of issues that we have, that it's implicit bias, incredibly important, but we can't forget about explicit bias, and that's still a problem, and there's a lot of work for all of us to do to create the kind of society, the kind of system, the kind of state, and city that we want And I think that we have the kind of nonconformist in this room who can make that kind of change. So despite while I'm saddened by that story, I'm still hopeful for the future. Join me in thanking Professor Shan and Judge Alexander.